Hi, everyone. Thanks for coming. This session is called Opening Doors, Equity and Access for People on the Sex Offense Registry. My name is Mihir Vora. I'm going to be the moderator. My pronouns are he, him, and I'm from Home Base. Home Base is a nonprofit dedicated to building community capacity to prevent and end homelessness. And in particular, I'm from Home Base's Criminal Legal System Initiative, where we believe that true public safety requires that everyone have access to safe, stable housing. And to do that, the Criminal Legal System Initiative at Home Base has a few areas of focus. We do cross-sector workshops and foster partnerships. We do visioning, planning, troubleshooting, and implementation. We create curated tools and resources for communities and agencies, and we do peer-to-peer learning and community building. So our goals for this session are first to unpack assumptions about the sex offense registry, to understand California policy changes that affect housing for people on the registry, then to reflect on how we can prevent discrimination against people on the registry, and finally, learn about cross-system partnerships that support housing for people on the registry. If you're joining us virtually via Zoom, feel free to introduce yourself in the chat. And if you have any questions, you can submit them in the Q&A. If you're joining us in person and you have any questions, you can raise your hand, and the in-person staff member will let me know via Zoom chat, and you'll get a microphone to be able to ask your question. I'm going to start with a brief introduction, and then we'll get into our panel. So the criminal legal system is a major driver of homelessness and inequity. People who have been incarcerated once are 7 times more likely to experience homelessness than the general population. And people who have been incarcerated more than once are 13 times more likely. We know that 15% of formerly incarcerated people experience homelessness in the year before their incarceration, and that about 48,000 people per year enter emergency shelters directly from jail or prison. And in terms of equity, Black adults make up 13% of the US population, 33% of the prison population, and 43% of the homeless population. We also know that women are 2 times as likely to be homeless after incarceration compared to men of the same race, and that gay, lesbian, and bisexual people are 3 times more likely to be incarcerated and 2 times as likely to experience homelessness compared to heterosexual people. 17% of transgender people have been incarcerated, and 47% of Black transgender people have been incarcerated. So that gives us a sense of how this is really an intersectional problem. So generally, populations that are already marginalized or vulnerable in society are hit harder by the effects of the criminal legal system. And in particular, what's relevant for this panel today is that we know that people who are required to register with law enforcement for sexual offense convictions are highly stigmatized. They face barriers to housing, to employment, and to healthcare as well. And misconceptions about people who are required to register, as well as the lack of information about the legality of many registry-related barriers, can prevent communities from connecting households on the registry with the stabilizing resource of safe housing. And it's important also to remember that safe housing is not only stabilizing for the household being served, but it's stabilizing for entire communities because it stops the cycle of homelessness and incarceration that prevents successful integration into communities. So what is your role? If you're joining us today as a housing provider, your role is to make sure that your program is not unlawfully or unfairly excluding people. And if you're joining us today as a case manager or an advocate, your role is to help prevent discrimination against your clients as they are looking for other housing. So we have 4 panelists this morning. Our first is Byla Lindner, who's a directing attorney at Homebase, and she'll talk about examining assumptions and myths about housing in the sex offense registry. Then we'll hear from Michelle Kumas, Deputy Public Defender at the San Diego Public Defender's Office, and she'll tell us how to get removed from the sex offense or 290 registry. Then Beth Hennigan, Executive Director at the Interfaith Shelter Network, will talk about Stigma, the 290 registry, and cross-system partnerships to provide housing. And then finally, Rosa Elaine Garcia, Program Manager at the Health Trust, will speak about how to find housing while on the sex offense registry. Then after our speakers, we'll have time for a Q&A, and then we'll wrap up with a little group reflection activity to think about steps we can take in our own work to better serve people on the sex offense registry. And with that, I'll turn it over to Byla.
Hello, good morning. Thank you for the introduction, Mihir. I just wanted to, just thank everyone for being here today and taking the time to join us to discuss this very important topic. I'm very, very happy to have you all here. So we're going to get started by examining some common assumptions and myths that folks might have about housing, the sex offense registry, also known as the 290 registry, and I'll be using those terms sort of interchangeably. We are going to, be taking the time to do this because being able to take a critical look at our society's established attitudes towards who deserves housing, quote unquote, and what keeps us safe, quote unquote, is critical to working with any stigmatized population. But before we get into things, I just wanted to acknowledge that talking about sexual offenses and safety concerns can bring up a lot of different things for people, a lot of different emotions, a lot of, different ideas and thoughts. So I thought I would just take a moment to give people a second to check in with themselves, to think about some of the following questions. The first one is, what does this discussion bring up for me personally? What does it bring up for me emotionally? What does it bring up physically? Am I feeling anything physically, as a result of being part of this conversation? What assumptions do I carry with me about people on the registry? And where do those ideas come from? Also, how might these ideas impact the work that I do with people on the registry? And how can I challenge those assumptions? What other education or resources do I need to make that happen? So now, carrying that sort of curiosity and thoughtfulness forward, on the next slide, I wanted to take a moment to answer the question, why are we talking about housing in the 290 registry, also known as the sex offense registry? First is that we are never going to end homelessness and related systemic inequities if we don't confront our biases and assumptions about people involved with the criminal legal system, including those on the registry. Second, people on the registry have some of the highest barriers to accessing housing of anyone in our society. This is evidenced by the fact that about 20% of people on the 290 registry don't have housing. And that is because people on the registry face many long-term consequences of their convictions that impact every aspect of their life. It's like a domino effect. And many of these consequences are the result of laws or regulations that are baked into our societies that purposefully prevent people on the registry from having certain living wage jobs or living in certain places, having certain kinds of housing. For example, Jessica's law in California is a law that prevents some people on the registry from living within 2,000 feet of a school or a park. And after that law was passed in 2006, the number of Californians experiencing homelessness on the registry skyrocketed from 88 people to 3,229 people over the course of 2 years. People on the registry also have a difficult time obtaining housing, not just because of the sort of legal consequences that are enshrined in law, but also because they're high visibility, because you can find them by looking them up on the internet. And the public stigma related to being on the registry encourages landlords and housing programs to exclude them without taking a closer look at the risk that they might actually pose. And we know all this is true because we hear housing program providers talk about it all the time, about screening people out through conducting criminal background checks. And for those that do serve people on the registry, by talking about how hard it is to help their clients find stable, affordable housing. All right. And so now turning to what do we actually know about the registry? Well, California requires people convicted of any one of over 100 crimes to register their whereabouts periodically with local law enforcement. And this list of crimes is extremely broad. It ranges widely from misdemeanors, minor crimes, to felonies. And examples of convictions that frequently require registration include public nakedness, selling sculptures or paintings depicting child nudity or pornography, sexting, rape, urination in public, and child trafficking. And the reason I mention some of these examples is just to drive home the point that not everyone on the registry is a violent predator. And there is like I said, a wide range of crimes that will land you on the registry. So, teenagers who have sexted with each other and shared images of each other as minors, and people who have sexually assaulted others are on the same registry and are facing the same consequences. We also know that the California Department of Justice's Megan's Law website publicly posts many registrants' names, addresses, conviction history, and appearance. And this is very different from the way our society treats any other convictions. For example, there's no public registry for people who've been convicted of murder or homicide. People on the registry reflect a full spectrum of economic status, racial and ethnic demographics, sexual orientations, gender identities, and ages, which means that, among other things, that there are many youth on the 290 registry who were convicted of various crimes while they were still children themselves. We also know that, as we briefly discussed, that being on the registry significantly restricts certain freedoms otherwise available to non-registrants, such as being on the internet, for example, doing an internet search to look for housing, applying for certain jobs, having certain jobs, and obviously restrictions that severely limit housing options. And on the next slide, we have some more facts about the 290 registry. So fact, many people on California's registry are there because of discriminatory law. So California has, I think, the first sex offense registry in the United States. It started in the 1940s, which means that many of the crimes that require registry reflect the biases and discriminatory views that were even more prevalent back then in the 1940s. So for example, because of homophobia, consensual same-sex conduct, which violated sodomy laws, landed people on the registry. And that means that there are people currently on the registry who, for example, engaged in consensual same-sex activity, for example, possibly in the 1990s or whatever. So this is just another example of, the fact that not everything is sort of how it seems with the registry and folks who are on there. In 2017, California spent $140 million a year to put youth on the sex offense registry, yet designated only $46,000 for victim services and prevention. And this is just to show that this is where our society is putting resources and to question whether we're really using them to address and prevent harm. Also, California's new tiering law is not automatic for those on the registry. And we're going to hear a bit more about that from Michelle from the San Diego Public Defender's Office in just a moment. But just wanted to point out that, there is this law that's going to allow some folks to ultimately get off the registry, but it's not going to happen automatically. There's a process they have to go through. So it's really important for all providers to know how to connect their clients to those resources, because again, it's not just going to happen automatically. Okay, and on the next slide, I'm going to talk about some common assumptions about the 290 registry. The first assumption is that housing programs can't serve people on the 290 registry. This is a very, very, very common misconception, and it really comes down to what kind of program it is and how it's funded. So, for example, some housing programs operated by public housing authorities are not allowed to serve people who are lifetime registrants. However, many other programs can serve people on the registry, but choose not to. And that's a decision that may violate California's Fair Employment and Housing Act, as well as Housing First principles. So for these reasons, it is really critical for your agency to understand what exclusions are actually required by law, because there are very few that are actually required by law, and where those exclusions are really choices that an agency is making to ensure that those discretionary policies are A, truly necessary, and B, not violating fair housing laws. Another assumption is that registries are necessary to help law enforcement and the public track people who present the greatest risk to the community. It's important to understand and to know that the majority of people who cause sexual harm are never arrested or prosecuted. And therefore, they're not on the registry, right? They're not on the registry. And the other reality is that the 290 registry is so broad and has so many people on it that managing it actually takes away resources from law enforcement that, that they could be using to provide more supervision and support to higher risk folks. And then the last assumption is a big one, and it's probably the hardest for us to overcome, because if it crumbles, it means that there are some fears that we just cannot insulate ourselves from. And it means that we don't necessarily have control over everything in our world, right? And that's hard. And I think a lot of people feel that if they can restrict housing, they have some control, right, over how safe their housing program is, how safe their world is going to be. And the truth is about the registry is that, first of all, it just restricts where people can live. So even if we forget everything I just said and assume that everyone on the registry poses a risk, the registry just impacts where their physical home is. It doesn't impact where they can go. It doesn't impact where they can work. So for example, you could have someone who lives near a playground or who cannot live near a playground, but who works next to a daycare center. So these are sort of nonsensical. And we also know that most sexual violence occurs between people who know each other. They're close contacts, right? It's not something that restricting housing access to people in your programs is necessarily going to address. And in addition, true public safety comes from addressing root causes of harmful behavior. And denying stable housing to someone makes it that much harder for them to address those underlying issues and therefore improving public safety. So thank you for listening to me and hearing some of those assumptions and facts. I'm going to now pass it back to Mahir.
Great. Thanks so much, Viola. And now we'll hear from Michelle Kumas from the San Diego Public Defender's Office. And Michelle, I'll let you share your screen.
Hey everyone, can you hear me and see my screen?
Yep.
Excellent. All right, so my name is Michelle Kumas. I'm an attorney from the Public Defender's Office here in San Diego County, and I've been with the office since 2013. I've handled misdemeanors to homicides, but my current assignment is on the Fresh Start Post-Conviction Relief Unit, where we provide a variety of different types of relief. But I am the point person for SB 384, which is Senate Bill 384, the law that allows for people to petition for removal from the registry. And I'm going to go over what's necessary to know about how to get removed from the registry. So Senate Bill 384 was signed into law in 2017. And before that, as was mentioned earlier, all offenses, all sex offenses, misdemeanor peeing in public versus, violent sexual assault, all sex offenses in California required lifetime registration. Senate Bill 384 was signed into law because after a review of the registry. It initially was created as an investigatory tool to help law enforcement identify suspects in sex offenses. But what ended up happening is that too many people were on the registry and that it no longer became an effective tool because there were too many people who were potential suspects. And after a review of a robust amount of empirical research and studies that were conducted, it turned out that after somebody who commits a sex offense spends a significant amount of time in the community not reoffending, the chances of them reoffending substantially drop. And the amount of resources that were being used by law enforcement agencies to monitor these people was not actually beneficial because they were keeping track of people who were no longer at risk of recidivating. And so the legislature took all this information to account and they signed into to law Senate Bill 384, which modifies Penal Code Section 290 and also created Penal Code Section 290.5. So what did the modifications do? It created a new 3-tiered registration system where it's not just one size fits all, it depends on the particular offense. So if your offense falls into a tier 1 offense, then if you committed it when you were a juvenile, then there's only a 5-year requirement where you have a minimum registration period that you have to register for before you can petition for removal. And for adults, it's a 10-year minimum registration period. If your offense falls into a tier 2 category, then as an adult, you have to register for a minimum of 20 years before you can petition for removal. And if you were a juvenile, you have to register for a minimum of 10 years. And if your offense falls into a tier 3 offense, then as an adult, you still have to register for life. But as a juvenile, that's not applicable. So for juveniles, there's no lifetime registration ever, but it's only for adults. Now, the minimum registration period starts upon the date of release from incarceration or placement or commitment, including any civil commitment on the registrable offense. So when they get released from custody, that's when it starts. But it can get extended with each failure to register conviction. So if you fail to register, you can be prosecuted for failing to register. If you have a misdemeanor failure to register conviction, it adds an additional year to the registration period. If you have a felony failure to register conviction, it adds an additional 3 years to the registration period. The registration period gets tolled during subsequent incarcerations resulting in adjudication. What does that mean? That means if you're put on probation and you are violated and you go back to jail for a 6-month period, that time does not count towards the 10 or 20-year period. It would have to be an additional 6 months of registration before you can petition for removal. And it restarts upon any new sex offense conviction. So if you're convicted of an offense in, say, 1999 for a tier 1 offense, and then in 1998 you commit that same offense again, you would not be eligible for relief in 2009. You would have to wait. You'd have to start all over again. Sorry, those dates are wrong. If you're convicted in 2000 and you commit another offense in 2009, you would have to start again at 2009 and go 10 years rather than having 1 more year to petition for removal. So that's a very kind of quick summary of a very complicated law that has a lot of moving parts to it in determining what offenses fall into what tiers, but that's the basic gist. That's for Penal Code Section 290. For Penal Code Section 290.5 that was created, that's the law that governs the process for how these individuals who are eligible can be removed. So it all starts with the Judicial Council CR 415 form, which you can see a screenshot on the form of the form on the screen. It's a mandatory form that has to be filled out and submitted to the court, along with proof of current registration, which is a document that the registrant can get from the law enforcement agency where they register. And once it's filed, they must also provide proof of service. It must be served on the district attorney and the law enforcement agency in the county where they are registering. They have to petition in the county where they're registering. And they also have to serve it on the district attorney and the law enforcement agency in the county of conviction if it's different from the county of registration. What does that mean? That means if somebody was convicted in LA, but then they moved to San Diego and they're registering in San Diego, they would have to petition in San Diego and serve the petition on both the district attorney and the law enforcement agency in San Diego. They would also have to serve it on the district attorney and the law enforcement agency in Los Angeles. And the reason being is because they don't want to have, they don't want to make people go back to where they were originally convicted, because they understand, the struggles with homelessness, and if they're in a particular place, going back to the county conviction may not be an option for them. But they want the court where the petition is being heard to be properly informed about the underlying facts of the case, which is why the district attorney and the other county of conviction would be notified and be able to provide that information to the court where the petition is being considered. Once the petition is filed, the law enforcement agency where they register they must file a report within 60 days to determine whether or not they are in fact eligible for relief. Once law enforcement files that report, the district attorney then must file their response within 60 days of that report, indicating whether or not they oppose or if they have an objection. And then the court has a specific form that they use to rule on the petition. So that's the basic process for how it works. If you know somebody who is on the registry who you think may be eligible for relief, we do have these pamphlets that we have passed out to all the law enforcement agencies so they can hand it out to the registrants. But if you know somebody who is in San Diego that you think maybe benefit from this, we can provide these and make these available. Additionally, if they're interested and they are seeking the assistance of the Public Defender's Office in San Diego, then they can fill out this, it's a Fresh Start application form. It's a 2-page form. It has contact information in the beginning, case information, and then additional information about whether or not they're on probation or in custody or have any other charges. So in order for somebody to be removed from the registry, they must not be on probation for anything, any sort of supervision. They cannot be in custody serving a sentence, and they can't have any pending cases that could change their tier or their registration time period. If they are seeking relief, they can just check the box that says PC-290 relief, but they can also look at the other types of relief that we offer. And if there are other types of relief that we think are applicable, we can also help them with that as well. And they can fill out the additional information, what they're seeking, what their struggles are, and they can submit it. If they submit an application asking for help, then it would be my request that they attach with that application their tier notification letter and proof of current registration. So the Department of Justice has gone through, or is in the process of going through all of the registrants on the registry and placing them in their appropriate tiers. And they have these tier notification letters, but it requires the registrant to go to the law enforcement agency where they register and ask for that tier letter. And also, in order for anybody to file a petition for removal from the registry, they have to attach proof of current registration, which on the right side of the screen, this is the form, official form that has been created. But if they only have the traditional registration, the 6-page document where they initial along the sides and sign at the bottom, that would work too. But this is the official form that was created. Both of these documents are necessary before I can file a petition for removal. And just so you guys know, the law enforcement report that gets filed looks like this. It has some information about, the petition, the date, the offenses. They do some calculations, and then at the end of the day, or at the beginning of the second page, it just says the eligibility determination is that this particular person was eligible, and there's extra, worksheets they attach showing, their calculations and whatnot. But once this shows that they're eligible, then the only thing holding them back from getting relief is the district attorney. And this is the form that the district attorney has to fill out. As you can see, there are 3 choices. They can say that they have no objection to the petition, which is my favorite. They can say that they object and request a hearing. There are 2 bases for requesting a hearing. The first is if they believe that community safety would be significantly enhanced by the petitioner's continued registration, or if they believe that they haven't met the requirements for whatever reason. And last, they can ask for a summary denial for a variety of reasons, but hopefully none of those would be applicable if we do our due diligence and research and make sure that they're eligible for before we file. One thing I want to emphasize is that, you know, the district attorney is going to be doing a very important, or I would say involved review in determining whether or not community safety would be significantly enhanced by the petitioner's continued registration. I've spoken at length and given presentations with the district attorney about the steps that they take in order to make a decision about whether or not to object. And they review, static factors such as the facts of the underlying case. They get the internal case file that they had, and they reach out to other counties if there are other cases out there to give them additional information. And they also look at the current dynamic risk factors, if they've had any recent police contact, if their district attorney investigators have any other information that they've gathered, and they also reach out to other law enforcement agencies to get additional information. So I want to make this a warning, and I'm glad that it was mentioned earlier that it's not automatic. It's not just the tenure happens and then you get off. It's not, you have the tenure happens and you still have to petition before you can get removed. And only until you get the court order granting it can you stop registering. But even if you are eligible, there's still this hurdle that has to overcome. And this is the email that I send to all the registrants when I file for them, letting them know, there's these timelines, but also if there is an objection by the district attorney, then we're going to have a hearing with the court to present evidence as to why they are not a risk to the community. And then ultimately the judge will make that determination. If there is no objection, like I said, the court grants without a hearing. And if there is an objection, then the court will set a status hearing to address what the appropriate next steps are. If there is a hearing to address whether or not community safety would be significantly enhanced by the registrant's continued registration, these are the things the courts consider: the nature of the registrable offense, the age and number of the victims, whether or not the victim was a stranger at the time of the offense, did they know them for less than 24 hours, any criminal and relevant non-criminal behavior before and after the conviction for the registrable offense. For those of you who are interpreting this correctly, that means literally everything that this particular person has ever done in their entire life. The time period during which the petitioner has not reoffended, any successful completion of a sex offender management board certified sex offender treatment program, and the person's current risk of sexual or violent reoffense, including any risk levels on any risk assessment instruments if available. I'm preparing for a hearing for community safety hearing that's going to be in a few weeks, and the district attorney's opposition was 177 pages. So they go, they don't mess around. They do their due diligence, they do their investigations, and they're going to present a lot of things that the court must consider. And then of course, the court, if they grant the petition, then they have to, the duty to register terminates upon the court's order, regardless of when the Department of Justice updates their records, but the court must notify the Department of Justice. And if the petition is denied, then the court must state the reasons on the record for the denial. And if it's based on the community safety exception, then the court must set a time period when they can re-petition. So even if it's denied, it doesn't mean you're denied forever and you can never petition for removal. It just means that you have to wait a certain period of time, and it's anywhere between 1 to 5 years. But the judge must state on the record the reason for that particular time period. And usually the judge will say, I need to see more of this, or I need to see more of that. And if in that time period you do what you're supposed to do, then the next time around it's likely going to be better for you. So you haven't lost all hope, even if it's not denied the first go around. And then the official removal from the California Sex and Arson Registry, which is commonly referred to as CSAR. What happens when the court grants it? The court clerk puts their data points, name, date of birth, things like that into an electronic system that is linked to CSAR, and then I will send the petitioner a copy of the court order. And then once the Department of Justice receives that this person has been granted the relief, then they will send this letter that you see on the screen to the petitioner as well as the law enforcement agency, indicating that their registration requirements have been terminated. And then upon request, I can get a copy of that letter as well. And I always tell the registrants, as soon as you receive this letter, you can feel confident that your name has been removed from the Megas Law website. It is no longer in the Department of Justice system, and law enforcement no longer expects you or requires you to register. But it is always in your best interest to make sure you have this letter before you do not register, because you don't want to run the risk of being falsely arrested for failing to register. That was very quick. I know I just went through it all, but that's the information, my presentation. If you have any questions, my contact information is on the screen, and happy to answer any questions if you have any.
Great. Thank you so much, Michelle. Now we will move on to Beth Hennigan of the Interfaith Shelter Network.
Awesome, thanks. That was super informative. I learned a lot, Michelle. My name is Beth Hennigan. I'm the executive director at a homeless service agency called Interfaith Shelter Network, or IFSN, in Sonoma County. And we've been around for about 30 years and have kind of targeted our services to different nexus points in the system that can kind of create and perpetuate homelessness. So I'm excited today to talk to you guys a little bit about stigma as it relates to the 290 registration and cross-agency relationships. So I like to start with definitions, and this might be kind of a basic one. I'm sure we all know what stigma is on some level, but for context, according to the APA, or the American Psychological Association, stigma is defined as the negative social attitude attached to a characteristic of an individual that may be regarded as a mental, physical, or social deficiency. A stigma implies social disapproval and can lead to unfairly to discrimination against and the exclusion of the individual. So I think that last part of that definition really sticks out to me, because it seems that individuals on the 290 registry are often excluded from housing, and as Mahir mentioned earlier, also from like employment opportunities and different things. So it's a little tricky with this population, but maybe we can go to the next slide. So I think stigma happens for these folks sort of like at every level, kind of an accordion style, a vertical accordion, I guess it is today, of different factors at different levels. So if we zoom out a little bit and take a look at more of a macro scale, culturally, societally, different economic structures are really consistently marginalizing and screening out this target population. Culturally, you know, I think if we're talking about folks who've spent time in state prison settings or different jail settings, the culture as it relates to folks serving time for registrant offenses is pretty aggressive. It can be, you know, like I think custody in general can be traumatic for this population, maybe even a little bit more so. And then out here, it's almost, I mean, depending, right? Of course, I don't mean to generalize cultural attitudes, but it can be a lot different, more like they become more invisible in some ways in larger cultural places. They don't get really a place at all in terms of social status. And how do you even engage with economic structures when you're screened out of most employment opportunities? So if we kind of look back in at the more zoomed in level, what does it look like in your neighborhood? You know, how does it land with landlords that you're working with, or if you are a landlord in your kind of organization? What about employers? We all know that income is a super important part of maintaining housing. So what local businesses, if any, support employment opportunities for this population? And I think having a sense of that macro scale and the more local picture when it comes to stigma with this population is a really important part of providing services and advocating for this target demographic, because, you know, there's a lot of conversation that has to happen around housing placement, successful housing placement for this demographic. And of course, like any kind of, you know, stigma or bias, we have to look at ourselves, right? So among the provider group that you're working with, what's the context here? How's the system providing services for folks on the registry? How many shelters locally are even accepting this population? How many permanent supportive housing units are available? All that kind of stuff. Also within an organization, we've been serving folks on the registry for the whole time that we've been in organization. And, you know, people come in with stigmatized beliefs and that are conscious or unconscious. And so at what point do you really start that conversation with folks? At our organization, we actually start in an interview very transparently, like we're working with this target demographic and this is what it can look like and what comes up for you. I think the other aspects of training that are important is like how training in tenacity, you know, there's a lot of no's before there's a yes in terms of like a rapid rehousing style approach with this demographic. So how do you kind of keep applying anyway and motivating people to keep applying anyway? And really, like, what does it look like when stigma's in play? Definitely people have to deal with the discrimination that comes up with employers and landlords, but how do we catch it when it's providers and how is it affecting the participants? Honestly, I think that's a question for every organization to ask itself. I don't think that there is like a one size fits all kind of answer around how to catch it and recognize it and then what to do with it. But I do think sort of that demystification process around, you know, some of that education and all of that is super important. And I think within a system, it's also, as we engage as providers or landlords in a system, you know, we're not going to get to functional zero without housing this population. And so it's almost a great barometer of how the local system is integrating housing first policies, because it is a kind of a key part of housing first to screen folks in. I'll follow your lead me here. Thanks. we can change slides. So reducing stigma, in my opinion, you know, obviously cross-agency education is key. Responding to different misconceptions, providing facts. And I think holding the question, how do we bring dignity into this situation? And as was mentioned previously, this isn't just about dignity for the participant, right? Homelessness is problematic for the entire community. And so how do we create a more dignified alternative from custody to the streets and back again, potentially for this population? And so it's a lot of uncomfortable conversations with different actors and different systems, I think is what it comes down to. And like being willing to lean into that and show up to that for the goal of getting us all to functional zero, right? So I think part of this, that cross-agency education is really important. I'm a little bit biased because Sonoma County, we've developed these really great interdepartmental cross-agency sort of relationships with different stakeholders involved in this. But I do think that it's super important to get that educational piece to staff, to ourselves, to each other, from different vantage points within that system, right? So what folks that work with our organization are looking at around the barriers related to registrant offenders and housing issues, probation officers, you know, someone working in an employment office, they're all going to see a slightly different angle of those same issues. And so what is, you know, how are they educating their staff around this? And is it applicable or useful for ours? Or, you know, what kind of solutions come from these conversations about barriers in a localized way. So what works in Sonoma County doesn't necessarily work in LA, right? For a lot of reasons. But I think having the conversations across different parts of the larger kind of continuum is a really key piece. So to get a little bit more specific, I guess, about Sonoma County and what it looks like for us in that county. So our organization, like I said, has been around for like 30 plus years. For that whole time, we've been serving the reentry population in various ways. In the last decade or so, we've really intentionally kind of gotten behind the wall a bit of certain partners. So we work really closely with the probation department. We actually have 7 houses that are transitional houses with the probation department. One of them is dedicated to sensitive needs populations. The local parole unit refers into a very large rapid rehousing program that we have for this population. Child welfare is not listed here, but is included. We have, we work really closely with child welfare as well. And so I think very intentionally by creating these relationships and having referrals come in through coordinated entry, you know, from these places, we operate a coordinated entry access point literally in the probation department. Parole sends folks constantly. So I think having or trying to create housing services embedded in these like larger systems, like that are often perpetuating, if not creating homelessness, is key, right? How do you provide a solution in the place where there are so many barriers? And having over years, having grown and fostered these relationships, the cross trainings are much easier, right? We can go talk about housing barriers with the officers that are holding those 290 caseloads. They can come and tell us all of the confounding things about the case-by-case issues for folks around the registry and like what specifically for this unique household is possible versus this other household. Local landlords, right? We're constantly trying to cultivate relationships with local landlords. And I'm sure Rosa Elaine will give us lots of tips about how best to do that in housing search for this target population. But like what works well and what do landlords need as part of this conversation from the housing provider to feel confident in taking in housing a stigmatized person. Again, the community-based organizations, like I really do think that housing first is such a, you know, I'm sure we're all bought in at this point. It's such an important model, and it includes this population. So what does it look like? You know, really, and how many people are asking that question? And how do we start the conversation in our COCs and with the people providing PSH or whatever it is? The other thing that's super relevant is like agency policy, right? So it happens at a direct service level, but it also happens at a higher level in the agencies, case by case. I think, you know, we serve families. We also serve 290s. And so what does that look like? How do we do it safely and according to, we don't want to jeopardize someone's freedom by, you know, placing them in a transitional facility next to a family house or whatever it is. So I think running things by the law enforcement agencies that hopefully are part of this conversation is always a great idea. We have separate days that we serve different demographics in the office. You know, like there's different kind of unique policy changes and creative solutions that I think can be implemented across the system of care and within an organization to really ensure that this is more possible, right? Because like I said, training in tenacity, like this is hard. This is really hard. And so how do we create solutions when there is so much resistance and stigma? and misinformation and unconscious bias around this specific demographic. Also, it's important to identify stakeholders in any continuum that have the ability to help people with this registration status increase income. Because like I said, we don't want to kind of create or put someone in a position where they're just more likely to get an eviction on their record after services end. So that sustainability piece is really important. We also have relationships with the mental health providers for treatment around sex offenses. And so I think, depending on the case, the amount of releases can be kind of overwhelming, I guess. So to get that kind of collaborative engagement going and enough consultation as needed, some cases that's not warranted at all. So, but I do think having the organizational relationships are super important in terms of actually creating some of those possibilities, which again can look really different on the ground in every location. But I think even with some of the COVID related housing issues, this population can really get lost. And so trying to figure out a team of people or a cohort of organizations to advocate for this population together and to continue to put them back into the mix, and question why they're being screened out, I think is takes a while to build, I guess, but it is an important part of serving the homeless community at large, I think. So that's really all that I had, Mahir.
Great. Thanks so much, Beth. And now we'll hear from Rosa Elaine Garcia at the Health Trust.
Hello, everybody. My name is Rosa Elaine, and I'm here with you today some of the strategies that I have worked with my team on finding units for folks that were on the registry. But next, I just wanted to share with you, as you have heard, transition back to society after imprisonment, it's a complex process and not very well understood. So I do see that sometimes there is an opportunity to educate some of these landlords that we work with. And it's always the primary outcome in reentry studies. So several factors can reduce recidivism and increase successful reintegration, including housing, employment, and social support. So the cooperation from the community and to empower individuals to change is an important factor. So I always try to educate landlords so they can be part of the solution and the support system for this population. Next. Now, locating housing or a unit for this population, it's not an easy task. I'm not going to lie. I'm not going to tell you yes. It could be difficult, but in many landlords use, and that's why it's important that we know what is it that can be done in California, what cannot, and what landlords are supposed to do or not. And that's where the education piece comes. I've had landlords putting on their even on the lease, that no sex offenders, and I said, no, I'm sorry, you cannot put this on your lease. You have to remove this your lease if you want us to work with you. And so educating and knowing what is it that you can do or should be done is important, so you can advocate properly with your clients, with these landlords. Next. So that's why I say knowledge is power. So do know what can be done. And so can sex offenders rent an apartment in California? Yes, they can. Definitely they can. So the fair housing law makes it illegal for landlords to refuse leasing to applicants with an arrest or a criminal conviction record. And what restrictions sex offenders may have in California? Unfortunately, they do have restrictions, and it's important to know what kind of restrictions they have so you can find and locate the proper unit. And a lot of, I do encourage clients to go and look for the units. So that is important that you tell them specifically what kind of units they can look. So they're going to get a lot of no's. We get a lot of frustration in, for getting all these no's. And I'll share with you some of my mistakes, encouraging clients go and look for units without knowing that, they would not be approved for some of the federal properties, right? So they will come and say, Rosaline, you sent me to all these units that I'm not able to. Oh my goodness, you're absolutely right. So I have to come back and do my homework to make sure that proper information. So knowledge is power. It will help you. So please know clearly what is it that you are able to do. Next. So how to find housing. The best way to do is try to work with private landlords. In our case, what I did, I was working with other housing programs that were not necessarily with for people that were on the registry. I was working with AB 109 clients. I was working with chronically homeless individuals that had nothing to do with the criminal. So I built up a network of landlords that already knew how I worked, what my team is able to do, that if they called, that we would be answering the phone right away, no matter what it was. We might not always have an answer, but we will always answer the phone. So you have a number of private landlords that already know how you work, that they know that you're going to be there for them. So then you have paved the road for more difficult and challenging clients. So then I approach them and saying, I have these clients, and so they will be more likely give it a try and accept some of my clients. So I would go to private landlords. Don't go to big property management companies because they have a lot of restrictions, and they will most likely will deny. So avoid those property management. So then in order to find those private landlords, small owners that are looking to rent units, you can do that on Craigslist and Zillow. But when you do that, don't go for those long that a lot of information, because most likely are property managers and they will probably not able to work. So just go by the ones that says owner, listed by owner, or available through homeowner. And that would be probably the best way to go. The other thing that I did was, because some of the clients, if you have areas on the application that are stronger, such as good credit, and they had been able to rent before, and you can get referrals from other landlords, get that information so you can put that on the application. In my some small companies, some small property, I overlooked the criminal history if you have a solid credit and a positive rental history. And if you can also include or add a little bit more on the deposit, that might give you a little bit more chance of getting that unit for your client. Now, the next one says be honest and confident. I do not encourage clients that they have to share what is on details, but if they do, I said just do it, be honest, and just do it with confidence, tell your story, and mention also what you have done to make changes and what are you doing. Landlords do, some landlords do appreciate honesty, and builds a little bit of a respect and trust with the landlord when you are honest. And if you are not able to do it in person, sometimes writing a little note or a letter explaining some of the situation, as I said, do not go on details. It might help on your application as well. But I only do this if it's necessary. I really don't encourage clients to share if they don't have to. The other thing that I do encourage is to be early and fast to apply. The rental goes fast. There's a lot of competition when it comes to renting units and apartments. So being one of the first 3 applicants gives you a better chance, gives them a better chance to be accepted. Not all landlords go in order of applications received. By applying early shows interest and motivation. So I do encourage clients to do that. And then I do search the registry. I use the registry. I remember using it in two different ways. Sometimes I would find units and I wasn't sure if the PO was going to accept that unit, because sometimes they have to be approved by the POs. So I would go and check on the registry to see if that was in an area or if there were other ones, other registrants living in that place, to see if the PO would eventually accept that unit. Or if I didn't have any units at all, I would just go in the registry to look to see if there were any apartment buildings or any other units there. And I would contact the landlords to see if they have any open. Most of the time people have a 30-day notice to give to landlords. So, I always ask if there were any notices given, and if there's any apartments coming up in 30 days or so. I would be interested in see if I could my clients apply. So that's how I would use the registry to see if I could find other units. I would also contact churches and nonprofit, because sometimes they do work with this population, and sometimes they do own units that are be willing to work with us and the population. So some churches were very effective. I have to say, in Contra Costa and Solano, we had a group of landlords, and I forgot to mention this at the beginning, of the private landlords. We had a number of sober living environments that were working with us, and they would sign an MOU. We knew that we could send our participants right away, so they wouldn't have to be on the streets. So I would have a number of specific living sober living environments available for clients as a temporary place until we would find more regular or a more permanent units. Like I said, I encourage clients to look, but we would have to be specific on where to look, so they don't get as many no's as they are, and prepare them to all those no's, because they will be denied. But don't get discouraged, because there are landlords out there that might be flexible and that might be understanding, that are willing to work with us. And to stay in touch with POs. In some of the counties, the referrals would come directly from either probation or parole officers. So we had immediately knowledge of who we were working with. So we would be in touch, and we would know exactly what restrictions and what type of units we should be looking for these clients. And so it was important, and we had regular meetings. So if we were having some challenges, we would have regular meetings with the POs, but be careful with what you share, because there are staff that sometimes, you're trying to build this relationship with your client, and there are certain things that sometimes come up on these meetings that we don't know that they're not supposed to do. And the POs do hear that, and next thing, they are going to do a surprise visit at these independent living environment places, and by something that we mentioned innocently, without knowing that it was not something that they were supposed to do. And so it took some conversations with POs and say, this is the work that we're trying to do, and by you doing this kind of stuff, it defeats our purpose. So we need to work, and we had the support, they understood. And so it was nice to be able to do important collaboration. I think that was something that it was very useful, very important, and key for the success of our program. And I think next. So I just, don't give up. It is finding appropriate housing for this population is difficult, but not impossible. The search can be extremely frustrating when the applications are denied, but don't stop, keep searching, and you will find understanding landlords. And do not push, because sometimes we do is like, sometimes we force certain situations just because we're desperate to get that unit at that person's house, and usually doesn't work out at the end. So I would just say, it's better to find somebody that is going to be a good partner or a good person that is a good landlord that is going to be supportive and understanding, than just trying to find it just, without that support. And I think that's probably all I have in terms of tips and what is it that we have done, my team and I have done to find housing for 290s. Thank you.
Great. Thank you so much, Rosa Elaine. So now we have some time for questions for our panelists. If you're joining us on Zoom, you can feel free to add those into the Q&A box. And again, if you're in person, you can raise your hand and Housing California staff member will give you a microphone to ask your question. And everyone can feel free. You can ask questions for all of our panelists, or if there are any particular ones in mind you have to ask your questions to, we welcome those as well. And it looks like we'll start with a question from the live audience.
Hi. I wanted to know if people who were on the registry, have you had any luck applying with affordable housing?
Unfortunately, I have not had any luck. In fact, I have to tell you, it broke my heart once. I had a client whose wife was in an affordable housing, but he was not allowed to live there. And it was really sad that I had to find a unit for him, and his family were in a different place. So no, I'm sorry.
Yeah, it's pretty often or common, I guess, that low-income housing is federally funded. But I think the only other strategy that we've come up with is room rentals for folks who have a lower income, whereas Rosalina mentioned partnering with an SLE, if that seems like something the tenant wants.
If you have someone that's on the registry and it's, like 30 years ago and it's for urinating in public, and they are in the process now of trying to get off that registry based on the tiering system, if they get denied for housing with a housing authority involved, is that an appealable situation? Like, I don't think that we ever talk enough about appealing decisions that are made by housing authority for a lot of people. And just in the last 6 months or so, the program that I run, we've been having conversations about, instead of just accepting no, appeal everything that you can, because they might just turn it around. So is this something that we could appeal, specifically with something as simple as, I was homeless, I had no access to a bathroom, where else was I going to urinate but outside, since that's where I live?
I'll speak to that again. Sorry. We appeal a ton, like almost every voucher application that we submit. And I think it works really well to start appealing at the point of, or to start prepping the person for a denial and appeal at the point of referral. And, like letters of support from other community members or their natural support network are always helpful. But anyways, Michelle.
I was just going to say that, that, like I mentioned, there are like specific time constraints that are in place. Once you file the petition, there have to be responses, there have to be reports, there have to be, it has to be processed timely. And I didn't give any stats during my presentation, but I'm happy to say that I have filed somewhere over 150 petitions, and I would say so far in the process, there's close to 70 have not been opposed. Granted, that's in San Diego County. I don't know how things are in different counties or where you are in particular. But for somebody who's in a tier 1 offense, if they have not had any other offenses, the likelihood of them being removed from the registry, at least in San Diego, is high. So I would say that if you are going to appeal anything, having proof of the pending petition, but I think would be something very persuasive and compelling to help you in that appeal process.
And I have to say, if you were if you're referring to the appeal about housing, I always do encourage clients to appeal, but I do usually contact the property manager. What are the likelihood of, this appeal help? And even if we don't get it, I was just to make it noise and making, maybe hopefully that will encourage them to change some of their policies or as well.
Yeah, I want to respond to the question regarding affordable housing. As a management agent in affordable housing statewide in California, there are affordable housing opportunities, and the key is for landlords in affordable housing is that you're working with a service provider. So if you find affordable housing that's oriented towards no place like home or permanent supportive housing, those types of situations, there are service providers connected. And there are other affordable housing programs and buildings that are connected with service providers that then help with that process. So there's very specific MOUs that are signed with management agents, owners, service providers, city and county agencies that give a very detailed process that at a point in time that there is identified a barrier, then there's a consideration of mitigating circumstances. I will say that when people say affordable housing, they think of HUD housing. HUD housing has a very restrictive line in the concrete about offenders. So that program is a barrier, but there are many other programs and many other affordable housing that there are doors that will open. And one of the key things I wanted to also say is that with landlords, it's not just complying with fair housing. The opening slide that you had there, it's really that landlords need to understand, and I think Rosa kind of addressed it, is that landlords need to understand that there is support there for the individuals, whether it's sex offense, it's criminal offense, it's homeless, it's that there are supports there to help that resident with being successful. Because as landlords, we don't have those tools. We recognize our limitations and that we can help with the housing and maintaining the housing and those kinds of things, but we don't know how to deal with those things. So to partner with service organizations that can provide that support, that's what opens the doors with landlords.
Thank you for saying that. That's true. That I have to say, it's basically, they take your client because of the support you're able to provide, and like I said, sometimes we don't have the answers, but we always answer the phone.
Thank you. This is really helpful. And I think this is a great panel. I had a question about whether, and I don't know if this would be Rosa or look at your names for the program operators. Do you have a screening tool that helps identify where you could be going with this particular person? So now that you've got the law changed and we have the tiering system, do you have a survey or interview form that you use that helps you determine how, what steps you need to take in assisting that particular person? I'm very new to this. I got a call from a woman whose the house she was living in, a tree fell on it. And so she was displaced. And it was only after she volunteered that she was in the sex registry that I was like, oh, now I don't know what to do. And so I was wondering if you had any kind of format that you use to help get the information that you need to make the appropriate decisions moving forward.
Yes, there are multiple psychosocial assessment forms, and there are some simple housing forms that available, and I'll be happy to share with you what I have available, and I think I have Google also looking, and HUD also has some forms and samples as well. But yes, there are. And and I don't know if you, please send me an email and I'll be happy to share with you.
The other thing that can be helpful in that space, trying to figure out what's appropriate housing for someone, is a consultation if the participants open to it with the supervising officer, if there is one, to kind of make sure that everyone is super aware of like where they can and cannot live. Sometimes folks don't have all of that information for themselves. And then also in terms of like assessment for scope and stuff, you can consult a bit about that if it's a concern.
Okay, it looks like there are no more questions, so maybe we can kind of shift gears slightly to our kind of final reflection and kind of synthesis activity. So kind of a question asking all of our participants, in person and virtual participants, to kind of think about what kinds of challenges do you worry about housing or starting to house people on the registry, especially when it comes to this kind of cross-system work. Like what challenges are you worried about? You know, what kinds of things do you think you need to better prepare? And if you have been doing this work, you know, do you have any tips or recommendations or resources for people in the room, virtually or in person, who are trying to move into this space?
We have another question.
Sure.
Well, we run a 211 line in Alameda County. We've asked many questions about, you know, we have done intake when a caller calls in, um, and that kind of a question, are you a sex offender, is touchy. And in general, I wondered, maybe not in a phone situation that might be inappropriate, but well, how do you ask the question, and how deeply do you, you know, in an interview, so that you can direct people and help them through the process? What do you ask, and how deeply do you ask the question? Like, what did you do? And, you know, that kind of thing. I'm just wondering, and is there a way to ask the question that's appropriate or even legal?
I think, you know, always thinking like trauma informed, right? Is this question absolutely necessary, or does it change the outcome of the conversation? Is a good first questions, inner self question. But I think also we tend to just ask about criminal history. So, you know, do you have anything on your record? And not necessarily specifically about registration status, but if I were to ask, I'd probably ask if they had any convictions that led to registration status, because it could be arson or other things that lead there.
And then we follow that with, do you have any restrictions in where you need to live?
Hi. So I spent some time as an intensive case manager, and I think just some experience in the field. I think just remembering that like we are their advocates, and we are sometimes their only and their strongest support system. Um, and we have the ability to mediate a lot of situations is really important. But I think the biggest challenge that I've come across is the public. It's hard to change the stigma of sex offenders, and I know we all know that sitting in this room. I just wonder, like, I'm always trying to think of how I can start small. You know, I think of like people in my life that I can start to change the dialogue around sex offenders with. It's extremely challenging, but I don't know. Do you guys have any suggestions on like starting small and hoping it has the ripple effect that changes, you know, essentially at some point communities, but then macro level stigma as well.
I mean, I think it starts small. I think that's how things happen. You know, like the cross organization, the cross agency relationships that I was discussing really started with like a couple cases years and years ago, and like just picking up the phone and like, I'm hitting this roadblock repeatedly. What do you see from your angle? How do we get around it together to support this person? Because yeah, it's super brutal to continue to go up against the same no and no, like Rosaline was saying, it's so many no's before there's that yes. And it's about resiliency building in a lot of ways, how to do that together.
To give some hope in response to that, it is, you're 100% right. The stigma is there. It's going to be there for a really long time. But I do think from the legislatures and the criminal justice's perspective, there is a pendulum that is swinging in the opposite direction. And it is clear based on this new tiered registry that not all sex offenses are going to be treated equally as they were before. And I think that a tremendous number of people are going to benefit from that, because now, even when we talk about cases, we refer to them as like, oh, this is a tier 1 offense. And it's like, it's already becoming not as serious in the eyes of even those in the criminal justice system. And even I work very closely with different law enforcement agencies, and even they are reaching out to me and saying, oh, this person doesn't need to be on the registry here, help them. So just, it's hard. And I know you guys are, on the ground and getting the nose and the door slammed shut in your face repeatedly, but just know that, it'll take time, but I think we're moving in the right direction.
I have to say, starting a small, even when I was building the team that was going to work with this population, just doing the training was sometimes challenging because Rosalie, how are we going to do this? And I think the knowledge was the key, teaching and learning that there was a wide range of reasons why they were on the registry. It was the eye-opening for my team, and then when they started to interact with clients, they were like, that when he was 17, he's got a girlfriend and the father reported him, and that's registry. That's not fair. I'm like, see what we're talking about? So there's a wide range of reasons why people are on the registry and not necessarily what we all had in mind before, right? So it's just learning about, and all those assumptions that Bailey present to us. I think it's important that we also share with the rest of the people.
Thank you. We have a few questions online, so I'm just going to read them out. The first one is a common landlord concern is, but if I don't screen for this, then I'm liable if something happens on the property. Any suggestions on how to respond to this?
I mean, I think that relationship between the providers and the landlords that the landlord from the audience was talking about can be helpful. I mean, that's obviously not going to shift any, like you can't guarantee any outcome with any person that you're serving, but having that relationship and the support network around the person can change outcomes sometimes.
But I would also suggest that landlord that he would have to legally know what would he be liable for, what is he talking about. So I'm not an attorney, so I refrain from giving any legal advice to any providers or any landlords, so I always say, do your homework, because they'd be surprised at what they're really not liable.
Thank you. Next question is, are there any citations that we can see about federal HUD COC funding not requiring screening for lifetime sex offender status?
Yeah, so what I can do is I can put the citation in the chat if that's helpful, because it is a legal citation, but essentially the COC program interim rule, which governs the COC program, um, says that if the housing has in residence at least one family with a child under the age of 18, the housing may exclude registered sex offenders and persons with criminal records that include a violent crime from the project, so long as a child resides in the house. So it's permissive, and it's sort of up to the program. But the whole idea, one of the key ideas behind the COC program is that it's housing first, and you're supposed to not screen people out. So in fact, and there's a lot of guidance from HUD that suggests that people should not be screened out based on their criminal records for the COC funded program. Now, housing choice vouchers, public housing, it's a little bit different depending on the funding stream. That's why I was saying you need to know what particular program you have. But I can definitely put that citation in the chat for sure. And just to note on the last question, another thing that I think might be worth being aware of is sort of what your client's rights are under the Fair Employment and Housing Act, which I'll also put a citation to in the chat, because landlords are also liable under that, right? They can be reported and deal with the state if they are denying people housing based on their criminal history information without a legitimate basis. And saying no sex offenders in this unit isn't going to cut it, because it has to be tailored to what the actual conviction was. So anyway, I can put some citations to that as well, if that's useful.
Thank you. And then the next and last question for online participants is, what effect would the public outcry over someone on the registry moved into the neighborhood by a housing program have on the housing program? How would that be mitigated so as to not negatively affect the housing program?
So like the transference of stigma is what we're talking about, it sounds like, which is a really awesome and interesting question. Like where I guess, like, where else would you want them? Is, like how it's a community issue, so it takes a community solution, right? And so we're just, as housing service providers, we're stepping up to that in the way that we can to help foster solution. Is how I would probably talk about that.
Thank you. And there's, I think we have time for one more question right here in the audience.
Hi, so I have two questions. To obtain the document for petitioning, would it have to be through the criminal justice system, or are we able to obtain off of a website?
The CR 415 form that has to be filed with the court, is that what you're asking?
Yes.
So that form is available online, I believe. It can be either through the court, the specific court, or the judicial council has forms that are made available.
Okay. And then also, what is the turnaround time for the whole processing of the petition? Is there a specific time frame?
So the law mandates that within 60 days of initially filing the petition, that law enforcement file a report indicating whether or not they're eligible. And then once law enforcement, they can do it sooner. I've had them do it within the same day that I filed the petition. But then the day that they filed, law enforcement files a report, then the district attorney then has 60 days to file their response. And if there's no objection, then the way that it is in San Diego is we have a very unique electronic filing system where everything gets filed electronically and goes down the train. And then once the DA has no objection, it just automatically goes to the court signs it, and then it gets granted and distributed. If there's a hearing, however, there's nothing in the code that requires a particular time frame by which the hearing has to take place, which is good and bad, because it gives you more time to gather documents, and there's no time frame for that, but it also gives the district attorney more time to find bad things if there are any out there. But that's, I would say, the fastest that we've gotten a petition granted and done has been, I think, somewhere between like 7 to 9 days. And then I think the longest it's taken has been I think it was like 3 months. I think has been the longest it's been. That's how it is in San Diego. I don't know how things are going in different counties, but
Okay, thank you.
Great. Thank you all so much for your time. I'm just going to quickly just do a little plug for Homebase if you're interested in our work and the work of Homebase's Criminal Legal System Initiative. You can learn more about us at our website. You can subscribe to our quarterly mailing list, and you can email us. Thanks again, everyone. I'll put these links in the chat too.